And we have a lot to talk about. There's a lot going on right now, of course. One of the main things we're going to talk about today is the Charlie Kirk assassination and the suspect in this case, who is now, they're going through evidentiary hearings, 5 days of hearings to talk about what the prosecution has. And that's pretty unusual in a case like this.
Yeah, definitely. So joining us now here in studio to talk about this is Josh Kolsrud, Phoenix criminal defense attorney and former prosecutor. So you have a lot of experience. You kind of know what's going on here. We were talking before we started here on FOX10 Talks, and you said this is kind of unusual to have this drawn-out evidentiary hearing of 5 days and not just send this to a grand jury, right?
Yeah, and Arizona has a very similar procedure. And so we do see this conundrum happen in Maricopa County. So just to kind of let the viewers know what's going on, whenever there are criminal charges, the state has the ability to either go to a grand jury or to do a preliminary hearing before a defendant is arraigned, where you'd actually have to say, I'm guilty or not guilty. And the reason why prosecutors go to the grand jury 99% of the time is that, number one, it's secret. So the only people that are there are the prosecutors and the grand jury. And number two, the defense attorneys don't get to ask questions of the prosecution witnesses. And, there's also an old saying, a grand jury will indict a ham sandwich, meaning that it's not very difficult to indict somebody when they're going before a grand jury. However, a preliminary hearing is different. It's almost like a mini trial, and it allows a defense attorney to cross-examine and question the state's witnesses, as well as being able to see the cards of the state. So, the state of Utah is taking a huge chance here by going to the preliminary hearing route as opposed to a grand jury, and having it televised as well to allow the viewers to see what's going on.
And Josh, I was just going to mention that it is being televised. We've been watching some of it as it comes in.
About an hour left,
yes,
I think.
There's some investigators right now on the stand there, an investigator named David Hull. What is the risk to the prosecution primarily in something like this, having this evidentiary hearing televised? Well, first of all, having it, but also televising it.
Yeah, I think it's great. We saw in the Carmelo Anthony case that concluded a few weeks ago that there were a lot of conspiracy theories about what happened or didn't happen. I remember going to the airport before vacation, and the cab driver was asking me what I thought about the case, and he was telling me how unjust the verdict was because Carmelo Anthony used a tool to sharpen cleats and not a knife, which isn't what the facts are. But it shows that if we're not even arguing over the same facts, then conspiracy theories are going to happen. In that case, there was not a live camera. And so it allowed people to kind of give their own interpretation of the evidence. And when there are live cameras, I think that you kind of avoid that uncertainty, and it gives viewers a certain amount of confidence in the proceedings that are happening. So I think it's actually really good in a case like this where there are so many conspiracy theories about what's going on. Now, to answer your question about how this can hurt the prosecution is that the prosecution witnesses are going to paint themselves into corners, meaning that when they testify later on at trial, if their testimony is different than it is during the preliminary hearing, the defense attorney is going to point that out and make it seem like they're inconsistent and maybe their answers aren't as reliable as what they're saying.
Interesting.
Yeah, very. There was Officer Badgley, former UVU police officer, was talking today in the courtroom. And he talked a lot about evidence. He mentioned that there was a pistol holster, an empty concealed pistol holster that was found, DNA on a towel wrapped around the rifle, matched Robinson. All of these things, this is key, right? These pieces of evidence, will that be enough?
Yeah, so what you're talking about is circumstantial evidence. And prosecutors kind of look at this like individual strands of string, and they're trying to make rope, like braiding rope. So you have the DNA that tells you that somebody touched something, right? Or it's, their blood is on something, an object. Here, it's on the gun holster. There's also shell casings and also the firearm itself. Mm-hmm. Also, you have surveillance cameras, and that actually gives a timeline to the DNA. So it kind of creates a story. And then finally, you have witness testimony that will testify as to what they heard and saw and give even more credence to the timeline. Because each one of those by itself, isn't going to push this case over the finish line for the prosecution. But taken together, the prosecution is going to be able to weave a story that makes sense. At least that's what the goal is. And the defense attorneys are going to look at, each string of evidence and look for what doesn't make sense, to say that maybe the timeline isn't as concrete as what the prosecution is saying, or maybe there is an alternative to why the defendant's DNA is on the gun holster, for example.
Yeah.
And this crime was witnessed by so many people, first of all in person, but then also, it was live. It was all over the place on social media. So many people saw what happened there in Utah. What kind of challenge is that for the defense attorneys now when you've got all of that evidence out there and pretty much everyone has seen it?
Well, it's huge, and it's huge for a couple of reasons. So in the state of Utah, the prosecution has to prove not only that the defendant committed the murder, but for the death penalty, they also have to prove a statutory aggravating factor. And here, the statutory aggravating factor that they have listed on the complaint is that the shooter, Mr. Robinson, placed thousands of people in risk of deadly bodily harm by firing upon and killing and assassinating Charlie Kirk in front of so many people. So the fact that it did happen in front of so many people is really the heart of this case, because the defense, their number one objective in this case is to have the death penalty taken off the table. And they're going to have to tear apart that aggravating factor.
The suspect, there was a handwritten note that was found. I think Kash Patel was the first person to reveal that early on. But this note said, allegedly, I had the opportunity to take out Charlie Kirk, and I'm going to take it. I mean, how does that go over in a courtroom? It's a handwritten note that was found. So what is that? What kind of weight does that carry?
Well, my first blush at hearing that makes me think of premeditation, that this wasn't some random act of violence, that the killer, he thought about this, he planned this, and that he executed his plan thoroughly. And, it's a huge piece of evidence that the defense really is going to have trouble explaining away. And you may ask yourself, well, how would they do that? Well, they're going to try to do that by showing that maybe he didn't write the note. They're going to say that maybe it came from somebody else, or that it was being taken out of context and it doesn't have anything to do with this case. But at first blush, it is a very damning piece of evidence.
Let's take a listen to a soundbite that we have. It's the officer talking about Charlie Kirk being shot. So let's take a listen to that.
At that moment, I saw him lean to the left. So
When you say him, you
Charlie Kirk. So I saw him go to the left because I could no longer see the right side of his body. So he went further underneath the tent to the north side of the tent, so left.
Okay. Can you describe the reaction of others that were there?
Yeah, so then everybody started getting up and starting to run in more of a chaos kind of situation.
Before you continue, can you describe a little bit? So you mentioned Mr. Kirk was answering questions, talking to individuals.
Yes.
Were there others present?
Yes.
Any idea about approximately how many? How would you describe it in your terms?
In my terms, I'd say when I was up there looking down, I'd say there's several thousand people, because you had it on the grass. It was jam-packed in the amphitheater, sitting on the grass. You had people standing on the back up along the cement. You had people that were on the second level, the Sorensen, and over by the Woodbury building. There's another level there where a lot of people were standing and watching. So it was pretty packed.
It really does seem like we're watching the trial.
Yeah, it does.
It's got that feeling to it.
It does, but the biggest difference is that the judge isn't determining guilt or innocence here. And what the judge really is doing is, imagine that you're a restaurant, and it's your opening day is coming up, but you have to get a bunch of clearances first from the FDA and state agencies, and so they come in and say, hey, the restaurant looks good, and you're all ready for your opening day. So that's kind of what this is. It's the judge looking at the case, saying, look, there's a lot of smoke here, and it's enough to investigate whether or not there's fire. And so it's just a preliminary stage to make sure that someone isn't being prosecuted and railroaded when there's no evidence.
In a case like this, obviously high-profile, death penalty on the table, Would a plea deal ever happen?
It's certainly a possibility, and it's what the defense attorneys certainly do want in this case. But when the death penalty has been alleged, the prosecution is saying we're not doing any plea agreement.
Gotcha.
We are planning on going to trial and alleging the death penalty.
What happens at the end of 5 days after this evidentiary hearing? What comes next?
Well, the judge will have to make a decision, and he can do one of three things. He can affirm the charges, that saying that what the prosecution has put forth meets the probable cause standard, which is 51%. So if you're 51% that he did it, then the case proceeds. The judge could also amend the counts, saying that, well, maybe you didn't meet the charge as it's written here, but you did the lesser included offense. So the judge does have an opportunity to kind of modify the charges if he wants to do that. Or he can say that you have not met your burden of proof, and we're going to dismiss the case, or we're going to dismiss a charge.
And they're talking, again, 5 days, full days, 8 o'clock in the morning all the way through 5 o'clock in the afternoon, early evening.
Yeah.
So basically they're going to be going over the entire thing here, all of it.
It's huge. It's really unprecedented that you would have, number one, a preliminary hearing in a death penalty case, but number two, a preliminary hearing that takes place over 5 days. I mean, talk about showing your hand to your opposing counsel. I mean, they're going to be showing everything that they have, and maybe that's the point. Maybe they want to show society that we're not trying to run and hide by going to the grand jury. Our case is so good that we're going to show the light, and we're going to get everybody behind us from this point going forward.
Josh Kolsrud, thanks for being in studio to talk about this. I'm sure we'll have you back.
Yes,
because there's no end in sight with this.
We always appreciate your legal expertise, kind of letting us know what's going on and putting it into terms we can all understand. So we appreciate that. Josh, thank you so much.
We'll be right back with some